Jerome, you sit front. Thank you. Okay. Well, it is a pleasure to teaching again at the International Disability Summer School in Galway. I was here at the first summer school, and now that's my second time I'm allowed to lecture. And it seems to me that this year it's a particularly interesting summer school, so many interesting participants, so many more participants. I expected 25 or 30, and great faculty. And while I was listening during the last days, I was wondering how many of us are actually lawyers and how many of us are actually political scientists or political activists or coming from other fields. So I wonder whether you could show me feet or hand or whatever you can use to identify yourself. How many of you are lawyers? Okay, and number. How many of you come from the field of political science or political activism? Parliamentarians, okay. And now, how many come from other fields? Okay, a good mixture of group. Thank you. This lecture is about multidimensional discrimination and disability interacting with other identities. Jared Quinn has very kindly introduced me as the only person in this world who understands intersectionality. Well, it is a nice compliment, which puts a heavy burden on my little shoulders. It is certainly not true, but I hope my lecture will bring some light into Jared's and other people's minds. Before I begin, let me tell you that I also had prepared a long list of further readings, which I think got lost in cyberspace the first time I sent it in, and it's now uploaded, so it might be good to go back to the website. As we all know, none of us has a one-dimensional identity. We all have an ethnic background, we all have gender, an age, a certain health or impairment status, a sexual identity, a religion or none, and so forth. People are categorized alongside these statuses, which is why they become what I call layers of identity. And because we have a history and present of inequality between human beings, these statuses can also be seen as axes of inequality, alongside which different kinds of discrimination are experienced. And for a long time, and still until today, we are used to see only one layer of this identity, as if they were the sole identity people had, and discrimination has been analyzed and combated in a one-dimensional way. Political programs, laws, and even social movements are a manifestation of the process. The civil rights or anti-apartheid movement has been focusing on racism only, the women's movement on sexism, the LGBTI movement on homophobia, the disability movement on ableism, and so on. Anti-discrimination laws tend to address discrimination alongside the above-mentioned categories. They prohibit racial discrimination, gender-based discrimination, disability-based discrimination, and so on. Similarly, we have positive action programs which target groups alongside these categories. Positive action programs for women, for older people, for disabled, for ethnic minorities, and so on, or gay and lesbians. The problem with such an approach is that it tends to create hierarchies of various layers of identity in different contexts, and that a significant amount of discrimination experiences is being missed or ignored. Poor programs targeting women tend to consider women as a homogeneous group, which is not true. There are old and young, white or colored, Muslim, Christian or atheist, lesbian or straight. And because of this homogeneous approach, Black women did not feel represented in the lily white movement of the women's movement in the US in the 80s. And this is why Kimberly Crenshaw introduced the term intersectional discrimination in the early 80s, and many other subgroups, so to say, followed that criticism, saying we are not represented in this white women's movement, or we are not, as disabled women, represented in the women's movement. Equality laws targeting discrimination based on a specific category ignore discrimination experiences that are based on a mixture of layers of identity. The most famous example is the headscarf debate. The prohibition to wear a headscarf in public schools adversely affects only Muslim women. It does not have an adverse effect on Muslim men. It does not adversely affect Christian women, except maybe the Queen of England, which tends to really like headscarves, wearing headscarves. It is, the problem is that we do not know how to analyze this kind of discrimination. Is it gender discrimination? Is it racial discrimination? Or is it discrimination based on religious opinion? Or is it all of this? Is it a mixture of this? And how do we tackle this kind of discrimination? Can be a mixture of all of this, and that is why anti-discrimination laws, which force us to decide it's either or, present a problem. Meanwhile, we have empirical data which shows that the majority of discrimination cases is multidimensional. It's most of the time the victims are so-called carriers of more than one marker, gender and disability, gender and ethnic minority, and so on. But the laws and the policies we have do not tackle most of these discrimination experiences. Within the next 15 minutes, I want to talk about the following issues. About two issues: multidimensional discrimination and what it is and how we define it. And secondly, I will talk about state obligations with respect to multiple discrimination under the CRPD and other treaties. And then I have prepared some group work, which will be facilitated by Agnes. Can you wave your hand, please, Agnes? Thank you. Andrea and Jerome, who has just left his seat. And we will separate in groups and work on some cases, and they are very complicated cases or statutes or situations which I created, which I think will help us tackle the problems. I don't know whether we all have the answers or whether we will find the answers today, but at least we can identify the problems. Okay. There has been a lot of discussion on what we mean when we speak of multi-dimensional discrimination and what might be the right terminology. Some people use double discrimination or triple discrimination. Others use compound, aggravated, cumulative discrimination, or intersectional discrimination. Some authors say, well, it's all the same. Others say, no, there are different kinds of multiple discrimination. Compound and aggravated or cumulated discrimination is discrimination based on several grounds, which can be clearly identified and separated, whereas intersectional discrimination is discrimination based on several grounds, but it is such a mixture of discrimination that it leads to very specific discrimination which has not been identified before as a form of discrimination, and that's why we need to separate it. Well, I come to that in a minute, what I prefer, but before I say what I prefer, I would like to also talk about definitions of discrimination, which is also important when we talk about multi-dimensional discrimination. Important definitions are direct discrimination, indirect discrimination, harassment, and violence. And what do we understand legally under these terms? Direct discrimination usually means that an individual is treated less favorable than another person in a similar situation for a reason related to a prohibited ground. For instance, a statute saying only non-disabled people have a right to vote. That's a clear-cut direct discrimination. Indirect discrimination refers to laws, policies, or practices which appear neutral at face value, but they have a disproportionate effect on a specific group. Typically in Germany, there are job announcements saying, this is a job for, let's say, cleaning a house, and we are searching people who are fluent in German. So it doesn't say in the job advertisement, we do not want foreigners or migrants. But definitely being fluent in German is something, a qualification people with migrant backgrounds have more difficulties to bring with them. So it has a disproportionate effect on foreigners and migrants. Denial of reasonable discrimination, denial of reasonable accommodation, denial of reasonable accommodation, we all know, of course, from the CRPD. It means the necessary and appropriate modification and adjustment, not imposing a disproportionate or undue burden in a particular case to ensure that persons with disabilities enjoy the same human rights as others. So it means adjustment, making changes to a specific situation in order to accommodate impairment. Harassment and violence are recognized in international human rights law as forms of discrimination ever since it was understood that sexual violence against women and girls does not happen because of destiny or because of biology, but because of patriarchal oppression. It was necessary that the CEDAW committee, which oversees the Convention against Discrimination, Convention against Discrimination of all forms of discrimination against women, they explicitly state that in a general recommendation because the CEDAW text itself does not outlaw sexual violence as a form of discrimination, and it is difficult to define sexual violence as differential treatment. Now let's come to the definition of multidimensional discrimination. As I already mentioned, there are different various terminologies: multiple, compound, cumulative, aggravated, intersectional. I do tend to use these terms interchangeably, and the argument is that any discrimination is unique and experienced differently by different individuals. I think it is important to acknowledge multidimensional discrimination, but I think it is not so important to distinguish these two groups. Does it lead to a unique form of discrimination, or is it just an add-on discrimination? So I will, in this presentation, use these terminology: multiple discrimination, multidimensional discrimination, and intersectional discrimination interchangeably. Now, what are the legal issues? There are a number of legal issues, at least 5 I want to mention here, which come up when we try to tackle multidimensional discrimination. And after that, I will talk about social policy issues which come up when we want to tackle multidimensional discrimination. So the first legal issue is that most anti-discrimination provisions are one-dimensional and miss out on non-dominant sub-minorities. Discrimination based on age may be outlawed, and the law may prohibit gender-based discrimination and disability-based discrimination. However, discrimination on the basis of a combination of these grounds may not be in the books. So does it not exist? Or maybe each ground is covered by different acts, and then which act do I have to turn to if I experience multiple discrimination? Second problem is definition of discrimination and justification. If we define direct discrimination as unfavorable treatment of an individual compared to another individual on the basis of a prohibited ground, multiple discrimination may not be seen illegal discrimination because we lack the precise comparator. Let's say a dance club gives free entrance to young women of color, but denies entrance to young and old men of color. Is that racism or sexism? It is You might argue it's not racism, but not because not all black people are denied access. Black women are allowed. Is it sexism? You might say, not all women are denied access to this club. More complicated becomes the matter when we have to deal with indirect discrimination. An employer dismisses all disabled women over 50 years, but says it is because the enterprise needs restructuring. So it seems neutral on its face. Since not all female employees are adversely affected by this conduct, it is hard to make a case for gender-based discrimination. Finally, if denial of reasonable accommodation is reserved for cases of disability-based discrimination, we have a problem to identify discrimination if the denial of reasonable accommodation is disability and age-related. As an example, we might take a blind woman who is over 60 and who needs a guide dog, but also fewer work shifts. Yeah? And then if she is denied those necessities, is that disability-based discrimination? Is it denial of reasonable accommodation? Yes or no? The third problem is the problem of evidence, particularly with respect to indirect discrimination. Statistics play an important role in proving discrimination. If women in a certain country earn 25% less than men, then we have a case for gender-based discrimination. It's clear-cut. But we rarely have statistics on the situation of all disabled women, of children with disabilities, and so on. And fourthly, there is a problem of recognizing multidimensional discrimination. Because most anti-discrimination provisions in our laws are one-dimensional, it is sometimes hard to recognize incidences of multidimensional discrimination, especially when it becomes, when it deals with harassment, when harassment is involved. Is the question, how do you dress yourself posed to a physically disabled woman? Is that a case of gender-based discrimination? Is that sexual harassment? Or is it disability-based harassment? Various analyses of discrimination cases have revealed that often courts treat multiple discrimination cases as a one-dimensional discrimination case just because lawyers have only been trained to see discrimination in one dimension. So even if there is evidence that the discrimination was based on gender and race, or on gender and disability, the court or the judge would only relate to one part of the experience. And finally, there's a problem of hierarchies among different discriminations and the problem of remedying multiple discrimination. The laws may differ in terms of justification and remedies and thus create hierarchies. For instance, gender-based discrimination may be strictly prohibited in a given act. But discrimination based on age and disability may be justified under certain circumstances. Gender-based discrimination may be sanctioned much higher than age or disability-based discrimination. So what message does such a law give to the victims of discrimination? Gender-based discrimination is always bad, but we can accept age and disability-based discrimination sometimes. It's less worse. Okay, these are the legal issues. Now I come to the social policy issues. Multidimensional discrimination will not be recognized if we are not trained to recognize multiple discrimination. That means that human rights violations remain hidden and victims are invisible in human rights policy and law. Then, because multidimensional discrimination remains unrecognized, there is a lack of research and data. And if we have a lack of research and data, this leads to a lack of effective policies to tackle multiple discrimination. These are at least some of the social policy issues, and since I'm not a social scientist, I'm a lawyer, I think I might have, other people might come up with more issues which are involved. Now I come to my Second point, the state obligations with respect to multiple discrimination under the CRPD and other treaties. If we look at the CRPD Convention, there are several provisions which talk about multiple discrimination, gender-based discrimination, children with disabilities are mentioned, discrimination on a number of grounds, like race, ethnicity, and so on, is mentioned in the preamble, and age is also mentioned with respect at least to statistical data. I have put on the screen all the provisions of the convention where you can find some kind of acknowledgement of multiple discrimination. Only Article 7 and Article 6 are standalone articles on specific groups of disabled people. Article 6 is on disabled women, and Article 7 is on disabled children. And only in Article 6 we find the word multiple or multi-dimensional discrimination. It's not mentioned with respect to children. And the CRPD, by the way, is the first international treaty which has binding language on multiple discrimination, but only with respect. Okay, time is running up. Thank you. So what we can say is that if we look at the text, yes, there is some acknowledgement of some subgroups, especially disabled women and children with disabilities, but what is intersectional discrimination? What is multi-dimensional discrimination based on disability, age, and gender is not defined, or there is no clear statement what are the state obligations. The only, with respect to women, there is some indication. It says states have to tackle multiple discrimination, they have to empower disabled women. But so we can say the CRPD is a modern law, but it is sprinkled with some wording on multiple discrimination, but it is not really a treaty which tackles multiple discrimination. What about treaty body jurisprudence? Well, jurisprudence by treaty body might be found in concluding observations on state reports, on individual communications, and in so-called general comments. General comments are authoritative statements on how to interpret some provisions of the treaty. The CRPD committee is a young committee. We have one individual communication out now, HM versus Sweden. We just adopted it in April this year. It does not talk about multiple discrimination at all. It's an interesting case, but that's why I don't go into the case now here. We have only 3 concluding observations out now. In all 3 concluding observations, you'll find some language on disabled women and disabled children with respect to each country. Tunisia, for instance, we said that the committee recommends under Article 6 that the state party design and implement awareness-raising campaigns against the negative perception of disabled women and against cultural, traditional, and family pressure that favor concealment of disabled women. But in none of the concluding observations so far, on Tunisia, Peru, and Spain, we have defined intersectional discrimination, nor have we said clearly what is the state obligation with respect to multiple discrimination. So what about the other treaty bodies? There are 9 other treaty bodies, and for a long time, none of the treaty bodies. Declaration of that World Conference Against Racism in 2001 had strong language on multiple discrimination and multi-dimensional discrimination. And since then, every general comment has some language on multiple discrimination in. And many more groups are now acknowledged in general comments of other treaty bodies. For instance, women from rural areas, disabled women, older women, ethnic minorities, and so on. But there is no general comment on intersectional discrimination yet. The best comment on which comes close to identifying the problems of intersectional discrimination is General Comment 20 of the Economic, Social, and Cultural Rights Committee. But even that committee, even that general comment does not define intersectional discrimination. It just says that states have to take extra efforts to tackle minorities among so-called vulnerable groups. To summarize, multidimensional discrimination is no longer ignored in international human rights law, but we don't know what it is exactly, and we know even less about how to tackle the problem. This is why I now trust in you to find great solutions for the cases I selected for group work. And I want to quickly introduce you to the cases. And the first, which will be facilitated by Andrea, and you will go with Andrea to another room, says, state, is it about an anti-discrimination law, different exceptions for different identities? State XY has an anti-discrimination law which prohibits discrimination on the basis of gender, race, ethnic background, religion, disability, age, sexual identity in the area of employment and goods and services. Discrimination based on a characteristic related to any of the grounds is justified if, by reason of the nature of the occupational activity, such a characteristic constitutes a genuine and determining occupational requirement. Additionally, negative discrimination based on disability or age is justified if it can be objectively and reasonably justified by a legitimate aim and if the means of achieving that aim are appropriate and necessary. And finally, in the area of tenancy law and insurance law, negative discrimination on the basis of all of the grounds except for race and ethnic backgrounds is justified if it is based on an objective reason. So here you have different standards of excuses for discrimination. So that's going to be group 1. Group 2 will deal with discrimination cases, and Jerome will facilitate that group. You have 2 cases. A non-disabled mother of a severely disabled child who is the only carer for the child is harassed at work whenever she needs to take time off due to her child's needs. Her supervisor once said, "You are using your," and then he uses the F word on the child, "you're using your child as an excuse for your laziness." She files a complaint, and the court decides that she has been discriminated against based on disability. Then there is a second case. A black man is denied access to a dance club because there are already too many black men in here. Other visitors, black women, white men, and white women, can enter the dance place. Now the question is, do you consider both cases as example of multiple discrimination? Or would you grant higher compensation for multidimensional discrimination? And the third case will be facilitated by Agnes for third group, and that is some non-legal issue. You are in a self-defense camp, and you organize this one-week self-defense camp for 30 women and girls. Participants are 14 to 67 years old. Among them are 10 non-disabled, 6 blind, 4 deaf, 2 learning impaired, 2 psychosocially impaired, 4 wheelchair users, 2 of short stature, 15 heteros, 12 lesbians, and 3 transgender. The curriculum of the self-defense camp includes A, self-defense techniques, kicking, boxing, shouting, B, mental training, how to feel in control, how to realize danger, and C, consciousness training. Experience, how do I realize that I've been discriminated against? And now you are in charge of organizing a C session, during which women should exchange their experiences with harassment and other forms of discrimination. How do you group the women? Please identify the advantages and the disadvantages of grouping in the women according to certain identities. So these are the 3 groups, and I think that we can say this is Group 1. Group 1 is facilitated by Andrea, and you follow Andrea. And then Group 2 will be the first 5 rows here, starting with the front row, which is not without tables. 1, 2, 3, 4, 5. Yeah, 5. And you are facilitated by Jerome. You stay here. You stay here.